Welcome to Justice at Work, Employee Rights and Protections in the Workplace.
Hello and welcome to Justice at Work, real talk from Filippatos, PLLC. I am your host, Kevin Rosenquist, and I am here with Gerry Filippatos from Filippatos Law, where fighting for fairness in the workplace is more than a profession, it's a mission. Each week, we're going to break down the rights you didn't know you had, the systems stacked against you, and the legal paths that can set things right. Whether you're facing discrimination, harassment, retaliation, or injustice on the job, we're here to help you understand your power and how to use it. Gerry, it's so good to have you here. Welcome.
Thanks, Kevin. Good to be here.
So today we're going to talk about workplace discrimination and at-will employment. So let's start with at-will employment. What does that actually mean, and how does it affect a worker's rights in New York?
Great question. So in most jurisdictions in this country, workers would be surprised to know that they have no right to continued employment. You get a job and you work your job, and the only thing that you're really entitled to is to be paid for the time that you work. Now, there are exceptions to that if you have an employment contract, if you're in a union setting, if you're in a municipal or other governmental setting, federal setting, then you have certain rights to continued employment under civil service law, etc. But if you're in the private sector and you don't have an employment contract, you can go in one day and your boss can say to you, you're fired, and doesn't have to have a reason for firing you, doesn't have to justify it in any way, and doesn't have to give you any notice. Again, with very limited exceptions, if it's a mass layoff, you have to get 30 days notice. So that means that you're really unprotected at work when it comes to your ultimate treatment, which is, having a job or not, except if you're fired or other adverse action is taken against you because you belong to a protected category. And that's where the anti-discrimination and anti-retaliation statutes come in.
Okay. What are some early signs that someone might be experiencing discrimination on the job?
So essentially, the concept behind the federal statutes and many state and local statutes that protect employees from being discriminated against in the workplace or being retaliated against for being concerned and expressing concern about discrimination is a pretty simple one, which is that you as an employee should not be treated badly, disadvantaged in some way, targeted in some way, because of an immutable characteristic that you have, whether it be your race, your ethnicity, your national origin, your gender, your sexual orientation, your gender identification, your disability, etc., your age being another one.
What are the exact laws that protect employees from discrimination?
So there's the Title VII of the Civil Rights Act, the Age Discrimination in Employment Act, ADEA, the Americans with Disabilities Act, the ADA, the Family Medical Leave Act, FMLA, and many more. It's kind of an alphabet soup. But to go back, I didn't really answer your last question in that the thing that you should be sensitive about is if you start to feel that you're being treated differently in the workplace, you're being singled out, you're being disadvantaged, you're being isolated out of meetings, you're being paid less, you're being treated more harshly than other people who are not in your protected category. So, for example, there's a concept in the anti-discrimination statutes called disparate treatment, right? So basically, if you're being treated differently than others who are not in your protected category. So let's say you're an African-American employee and you clock into work 5 minutes late, and you're in a team of another 5 employees, and the rest of them happen to be white, and each of them clocks into work 10 and 15 minutes late, and then you get disciplined. Your pay is docked, or you're suspended, or your boss, gives you a talking to, but not any of the white employees. That would be an instance of disparate treatment. And if you sense something like that, it's something that you should you should know that you should be on guard for, so that you can protect yourself and effectuate your rights.
Okay. No, I don't want to get off on a whole tangent here, but with
Sure.
the changes to DEI, is that changing the landscape as well?
Well, yeah. I mean, the statutes are the same. The
Okay.
federal statutes are not changed from administration to administration. We have laws in this country, and no particular president can change those laws without passing new laws. So, but this administration has expressed hostility towards the concept of diversity, equity, and inclusion, which embodies a lot of the fairness principles that we talked about in the anti-discrimination statutes. So I think companies are probably feeling a little more emboldened not to pay as much attention to the federal statutes, but that's where we come in, because if they don't pay attention, that means they're violating the law. And if they're violating the law and an employee does the right thing, which is speak up if they think they're being treated unlawfully, seek competent legal advice, then their rights will be effectuated. Because, in this country, we're still a country of laws. So,
Yes, hopefully we stay that way. Yeah, that was kind of a good lead into my next question. If someone feels like they're being treated unfairly at work, what steps should they take, and when is it time to reach out to someone like you?
So the number one step to take is to make a record, at least for yourself in the first instance, of anything that happens, like the scenario we just discussed. Or if it's a sexual harassment case, your boss, decides to ask you out to dinner, or decides to start invading your personal space and touching you in ways that you feel uncomfortable about. You should, at the very least, make note of when these things happen. So you have a record, a contemporaneous record that eventually will create evidence if the case is ever litigated. The next thing you should do, hopefully, is seek legal advice. And people should know that there are a lot of great employment attorneys out there, and we really take seriously our mission under the law, all employment attorneys, to really be private attorneys general, to really enforce the anti-discrimination statute. So you can call up almost any plaintiff's employment law firm, and you'll get an initial consultation, which will probably be free. Some firms are different, but we, for instance, have free initial consultations, and everything you say is confidential, and you can tell your story to an employment attorney, and they'll guide you as to what is going on and what your options are. So you should try to seek some preliminary legal counsel as early as possible when you sense that you're being targeted, you're being treated badly. The next thing you should do, either before or after seeking legal advice and making some contemporaneous record of what's going on that's bothering you, is to actually complain. Actually formally complain in writing. Email is a wonderful tool for preserving evidence of possible discrimination in the workplace. And the reason that's really important is going back to the employment at will doctrine, right? That we talked about. You can get fired for any reason. If you have a reasonable good faith belief that you're being discriminated against as an employee, and you then complain officially in writing to human resources or just your supervisor, someone of authority, at that point, you've engaged in protected activity, and you're no longer an employee at will. You are protected under the law, because if anything bad happens to you in the workplace, contemporaneously or shortly after you complain about the possibility of discrimination, that's a violation of law under the anti-retaliation provisions of the statutes. They all have anti-discrimination and anti-retaliation provisions. And a retaliation claim is as good as a discrimination claim. In fact, from a litigator's perspective, it kind of is a preferred claim, because it's easier to explain to a jury, because juries, depending on their experiences, their politics, their demographics, maybe they don't believe that discrimination still exists in the workplace, or it's a more abstract concept for them
Sure.
to understand. But everybody understands that if you complain to your boss might get upset and then might treat you badly. But
Hmm.
the thing is, if you complain about a good faith belief of discrimination and then your boss gets upset and treats you badly, they violated the law and you have a strong claim.
Okay. Yeah, yeah, it's a good point about the juries too, because of course, you hear stories about false accusations and things like that too. So that
Sure.
doesn't help. That doesn't help the jury's perception of what of what actually happened. And you mentioned the retaliation. I would imagine there's a lot of people who won't speak up because they're afraid of that
Exactly.
retaliation.
And that's the that's the sad irony, right? If
Yeah.
they did speak up, then they would be protected and they would have a good claim. And I mean, I've been doing this for 34 years almost now.
Wow.
It's sad, but as an employee, if you think that you're being discriminated against, likelihood is that you are.
Hmm.
And that doesn't mean that you're going to lose your job, or and it might be passing, and it might be and there are levels of discrimination as well. And there are cases that talk about, yes, we have to eradicate discrimination in the workplace, but the anti-discrimination statutes are not meant to be a civil a civility code for the workplace. Like, everybody doesn't have to link arms and sing kumbaya. They just have to
Hmm.
get along, do their job, and not treat each other badly, especially if one has authority over another, because of discriminatory animus. But the point is that, in your ability to effectuate your rights, the most important thing is to actually go on the record and complain, because that's how you can keep from going down the track of, you've been discriminated against and you're not being treated fairly at work, and then it keeps happening and it keeps happening, and maybe it impacts your performance, maybe something else happens, and eventually either you leave or you get pushed out. That's
Hmm.
typically what happens. But if you actually go on the record and complain, you might still get fired or diminished, but then you have a strong claim.
Right.
And I would say maybe even a majority of our cases are mostly retaliation cases.
Really?
And
Oh, wow.
employers pay a lot of money for violating the law. And like I said, a retaliation violation is probably one of the easier claims to put before a jury.
Well, that's really good information for anyone listening, because, like I said, a lot of people are scared to come forward. But I mean, if you really, you're right. If you really feel like you're being discriminated against, chances are you have those feelings for a reason.
Right.
And and then, yeah, if you do get retaliation, it strengthens your case. So that's definitely a good point to push out there. What you mentioned, documentation. Obviously, that's important in any case. What kind of records specifically would you like to see people in these situations keep?
Well, like I said, if if there's stuff happening via email that is evidence of discrimination or retaliation, you should um, be aware of what you're allowed to do and not do in terms of copying emails and retaining emails. But the law allows you, at the very least, to take a screenshot of an email that that you might think is evidence of discrimination or retaliation. So certainly do that. If there are incidents not involving documents, but involving verbal exchanges with people, like I said, you should definitely take, after something happens, take contemporaneous notes. And there are two schools of thought on this, and you have to check your jurisdiction because each state is different. But in certain states, you can record conversations surreptitiously in the workplace. If a state is what's called a one-party consent state, that means that if you and I are having a conversation and I decide, well, not I, because I'm an attorney, I'm under more restrictions in terms of recording under ethics rules, but pretend I'm not an attorney for a minute. I can just record the conversation, and I don't have to tell you about it, and it's not unlawful. It's not a criminal violation.
Okay, that's
If
something
we're
I
in
did not know.
If we're in a two-party consent state, that means that you can only record a conversation if both parties agree to it. So there's no surreptitious recording there. And in most of those jurisdictions where it's a two-party consent state, it's a criminal violation. Might just be a misdemeanor, but it's serious. So make sure that you're in a jurisdiction that allows you to record. And then let's say you're being harassed by your boss on the basis of your race. There are racial epithets being bandied about in the workplace. You might decide, I want to get evidence of this. I want to record it. If you're in a one-party consent state, probably a good idea to do that. On the other hand, some prospective clients come to us and they have hundreds of recordings. They've recorded every day of their employment for the last year. That's not a good thing, because all of that, if the case goes to trial, all of that is subject to discovery. It's all going to come out in a trial. And typically, most of the recordings are going to be inconsequential. So a skilled defense attorney is going to say, and this, supposed model employee spent all of his time recording his colleagues, sneaking behind their backs, and instead of doing his job, trying to prove discrimination. And we have 100 hours of recordings. And how much discrimination did we find in those 100 hours? 30 seconds, a minute. So that's not a good thing.
That's a really good point too. Yeah, because you can point to why were you doing this, and what were you supposed to be working when you were doing all this? So yeah, that could definitely backfire for sure.
And that's all to say, really, if I can stress one thing, and it's just, of course, we want you to come to our firm because, we believe we do our job quite well. But there are a lot of good plaintiffs' employment attorneys out there. If you have any notion that you might be being treated unlawfully, being targeted, being singled out, being retaliated against for saying something, just call an employment attorney. And there are a lot of good, I'll give a very quick plug to the National Employment Lawyers Association, NELA, that has a chapter in most states. So if you just Google NELA, you can find your local chapter, and they typically have some kind of referral service, of plaintiffs' employment attorneys, so you can get an attorney on the phone and tell them what's going on, and they'll hopefully give you some good advice. And everything that's said is confidential. And there are no obligations to retain that attorney or anything else. And again, I would say vast majority of plaintiffs' employment lawyers give initial preliminary consultations gratis.
Well, that's great information and a great way to kick off our podcast. That was a good first episode introducing everybody to you and what you guys do. Thank you so much for being here, and thank you for listening to Justice at Work, powered by Filippatos PLLC. If you're dealing with workplace discrimination, harassment, or as we talked about, retaliation, or even if you just want to know your rights, visit philippatoslaw.com to schedule a consultation. And don't forget to follow and share this podcast to help more people stand up for justice where it matters most, at work. Gerry, so good to have you here. Thanks again for your time.
Appreciate it. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.